Welcome to the High Court Report, your one-stop shop for Supreme Court coverage. Question for you. You ever get hit by a bus while stuck in traffic?
That sounds like the world's worst Monday morning.
Right? Now imagine you try to sue the bus company and they tell you, sorry, you can't touch us, sovereign immunity.
Wait, what?
That basically captures what we're talking about today in CSX Galette versus New Jersey Transit Corporation and the consolidated case New Jersey Transit Corporation versus Colt. The court will hear oral arguments on Wednesday, January 14th. A passenger gets injured when a New Jersey transit bus rear-ends a stopped car in Philadelphia. The passenger sues. And New Jersey Transit says, you can't sue us in Pennsylvania courts because we're actually the state of New Jersey.
Even though this happened in Pennsylvania.
Even though it happened in Pennsylvania.
Here's what makes this wild. New Jersey Transit runs buses and trains all over the tri-state area. They cross state lines constantly. If they get sovereign immunity from other states' courts, they could injure someone in New York or Pennsylvania. And those victims couldn't sue in their home state courts.
Exactly. They'd have to somehow sue in New Jersey, or maybe not at all. But here's the flip side. New Jersey created New Jersey Transit as a separate corporation. The state statute literally says, no debt or liability of the corporation shall be deemed to create a debt or liability of the state.
So New Jersey itself says it won't pay New Jersey Transit's judgments.
Right. Which raises the question, how can you be the state for sovereign immunity purposes when the state explicitly disclaims your debts?
That's the whole case right there.
Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundown, and follow on YouTube to see shorts. Just search the High Court Report. Questions about this case? Reach out to us via LinkedIn at the High Court Report. We actually read the messages. All right, here's what you need to know.
This case presents the following question. Whether the New Jersey Transit Corporation functions as an arm of the state of New Jersey for interstate sovereign immunity purposes.
Okay, so let's break that down. Interstate sovereign immunity means one state can't get sued in another state's courts without consent. Like if California tried to sue Texas in a California court, Texas could say sovereign immunity and walk away.
Right. That principle goes back to the founding. States agreed to give up some sovereignty when they joined the Union, but they kept immunity from being dragged into each other's courts. But here's the thing. New Jersey Transit claims it deserves New Jersey's immunity, even though it operates as a corporation, even though New Jersey law says it can sue and be sued, and even though New Jersey's own Tort Claims Act excludes New Jersey Transit from the definition of the state.
So the question becomes, when you look at this entity, how it operates, who controls it, who pays its bills, do you see the state of New Jersey? Or do you see a separate corporation that happens to get state funding? That determination matters because if New Jersey Transit gets immunity, accident victims in Pennsylvania and New York lose access to their local courts.
But if New Jersey Transit doesn't get immunity, New Jersey argues you're insulting the state's dignity by allowing sister states to haul its instrumentalities into court.
Let's talk about how New Jersey Transit came to exist, because this history actually matters.
Around the founding, public transportation didn't exist as a government function. You had private ferries and stagecoaches.
George Washington regularly used privately owned ferries in Virginia. Entrepreneurs would get licenses, sometimes monopolies, to run specific ferry routes, totally private businesses.
Same with stagecoaches. By the mid-17th century, you had regular stage service connecting Boston, New York, and Philadelphia. All private operators competing for customers.
Fast forward to the 1960s and 70s, New Jersey subsidizes private bus and rail companies. Then, in 1979, the state creates New Jersey Transit Corporation and starts buying up these private companies' assets.
So, New Jersey Transit took over buses from Transport of New Jersey in 1980, paid $32 million for them, then absorbed rail assets from Conrail in 1983.
Both formerly private for-profit companies.
New Jersey debated whether to make New Jersey Transit part of state government or spin it off as a separate corporation. They chose the corporate structure specifically to differentiate the workforce from civil service procedures and insulate funding from short-term political pressures.
Today, New Jersey Transit operates as what New Jersey law calls a body corporate and politic. It has 13 board members. The governor appoints 8 voting members and can remove them only for cause.
For cause, meaning you can't just fire them because you dislike their decisions.
Right. The governor also gets a 10-day veto window over board decisions, but no power to direct the corporation to take specific actions.
And here's the financial piece. New Jersey Transit earned $758.3 million from passenger fares in 2024 alone. It can raise money through fares, federal grants, advertising, leasing property,
And accepting private gifts.
but it also gets substantial state subsidies. Between 15% and 40% of its operating budget comes from New Jersey.
That number fluctuates year to year.
Now to the actual accident. Cedric Galette rides as a passenger in a car that Julie McCrae operates. They're stopped at a light on Market Street in Philadelphia when a New Jersey Transit bus rear-ends them.
In Pennsylvania, this detail matters.
Galette sues both McCrae and New Jersey Transit for negligence in Pennsylvania State Court. New Jersey Transit files an answer claiming sovereign immunity as an arm of New Jersey, then moves to dismiss. The trial court denies the motion. The Superior Court affirms. Both courts apply a multi-factor test and conclude New Jersey Transit doesn't qualify as an arm of the state. Then the Pennsylvania Supreme Court reverses. And here's their reasoning. They focus heavily on how New Jersey describes and classifies New Jersey Transit within the state's own structure.
The court looks at New Jersey Transit's statutory mission, providing coherent public transportation as an essential governmental function, its police powers, its eminent domain authority, the governor's appointment and veto powers, and concludes all this weighs heavily toward treating New Jersey Transit as an arm of the state.
The U.S. Supreme Court then granted certiorari to decide the issue. Let's talk about the arguments each side raises. New Jersey. Transit's first argument goes straight for state dignity and legislative intent.
How do they frame it?
They say New Jersey deliberately structured New Jersey Transit to perform essential governmental functions. The state calls public transportation an essential governmental function in the statute itself, and they argue federal courts must defer to how states choose to organize their own instrumentalities.
Right. New Jersey Transit invokes the word dignity 24 times in its brief. The argument goes, sovereign immunity protects states from the indignity of getting hailed into another state's courts. If New Jersey says New Jersey Transit shares that immunity, respect the state's sovereign choice.
What's their precedent?
They cite cases where the court looked at how state law defines an entity and its functions. They point to New Jersey Transit's police powers, eminent domain authority, allocation to an executive department, all things typical government entities have.
Exactly. And they emphasize New Jersey's historical choice. When creating New Jersey Transit, the state debated structure deliberately. They chose the corporate form for operational flexibility while keeping state control. Their second argument focuses on control mechanisms. The governor appoints 8 of 11 voting board members, can remove 10 of 13 total members for cause, gets a 10-day veto window over board decisions.
How do they respond to the for cause limitation?
They say for cause removal protection aligns with New Jersey's non-unitary executive structure. New Jersey gives many high-ranking officials for cause protection. So this doesn't diminish control. It just reflects how New Jersey chooses to structure its government.
That feels like circular reasoning.
Galette definitely thinks so. But New Jersey Transit argues these controls distinguish them from municipalities and private corporations that clearly don't get immunity.
Third argument, the financial relationship. This one gets interesting. New Jersey Transit concedes the statute disclaims state liability, but they argue the practical reality matters more than formal legal language.
Meaning?
New Jersey subsidizes 15 to 40% of New Jersey Transit's operating budget. That's substantial state investment. New Jersey Transit argues a judgment against them would necessarily impact New Jersey itself because the state would need to increase subsidies to keep the transit system running. So they're saying, even though legally the state doesn't have to pay our judgments, practically they would have to.
Right. And they claim this practical financial interdependence should count under the arm of the state test.
Okay, now Galette's response. This gets into some serious founding era history. Galette's first move hits hard. At the founding, corporations never got sovereign immunity, period. Doesn't matter who created them, who controlled them, what purpose they served.
That sounds like a bright line rule.
It definitely sounded that way for about 150 years. Chief Justice Marshall wrote in Planters Bank that when a government becomes a partner in any trading company, it divests itself, so far as concerns the transactions of that company, of its sovereign character and takes that of a private citizen.
So the founders actually debated whether states themselves counted as corporations?
Exactly. The Federalists argued states resembled great corporations and thus lacked essential sovereignty rights. The Anti-Federalists won that debate. States got recognized as sovereigns through the 11th Amendment. And then immediately the question became, what about entities states create?
Right. And the court held consistently. Corporate form decides the question. Doesn't matter if the state owns 100% of the corporation. Doesn't matter if the state appoints every officer and can fire them at will. Doesn't matter if the corporation exists solely for public purposes.
Give me an example.
Bank of the Commonwealth of Kentucky. The state owned it entirely. Appointed all officers. Could remove them at pleasure. Possessed unlimited power over the corporation. The court still said, no sovereign immunity.
Because it operated as a corporation.
Exactly. Corporations limit liability of their creators. That's the whole point. Judgments get satisfied from corporate assets, not state treasuries. That separation means no immunity.
What about the exception Galette mentions?
The real party in interest exception, super narrow, applied only when a judgment would get enforced directly against the state itself.
Like Hopkins versus Clemson. Plaintiff sued Clemson College over an embankment the college built. The embankment technically belonged to the state, not the college. So even though Clemson didn't get immunity as a corporation, the relief sought moving the embankment would run against state property. That triggered immunity.
But that exception doesn't apply here because New Jersey explicitly disclaims liability for New Jersey Transit's debts. No judgment against New Jersey Transit can run against the state treasury as a matter of law.
Now the modern test. Galette's second major argument, they focus on what they call the most salient factor, the treasury factor. This comes from Hess versus Port Authority.
What did Hess say?
That when the evidence on structure and control factors appears mixed, the treasury factor becomes dispositive, because the treasury factor homes in on the impetus for the 11th Amendment, the prevention of federal court judgments that must get paid out of a state's treasury.
And Galette's position on the treasury factor?
New Jersey statute, section 27:25-17 says, all expenses incurred by the corporation in carrying out the provisions of this act shall get paid from funds available to the corporation. Then critically, no debt or liability of the corporation shall get deemed or construed to create or constitute a debt, liability, or a loan or pledge of the credit of the state.
Pretty explicit disclaimer.
Galette argues that's game over. The state bears no legal liability for judgments against New Jersey Transit, and the court has said repeatedly it's the state's potential legal liability rather than its ability or inability to require a third party to reimburse it that controls.
That language comes from?
Regents of the University of California versus Doe. The court distinguished between legal liability and practical financial impact. So, New Jersey Transit's argument about the state having to increase subsidies doesn't matter under Regents. Even if New Jersey would practically want to increase subsidies, they have no legal obligation to pay the judgment itself. Plus, New Jersey Transit raises its own revenue, $758.3 million from fares, federal grants, advertising, property leasing. They can independently generate money to pay judgments without touching state coffers.
Third argument from Galette, structure and independence. They point out New Jersey chose to structure New Jersey Transit as a corporation with all the standard corporate characteristics. Can sue and be sued. Holds property in its own name. Continues existing regardless of state political changes. And New Jersey's own Tort Claims Act excludes New Jersey Transit from the definition of the state.
Right. The statute defines the state to include state offices, departments, divisions, bureaus, boards, commissions, or agencies, but explicitly excludes any entity statutorily authorized to sue and be sued.
New Jersey's own law says New Jersey Transit doesn't count as the state.
For state tort immunity purposes, yes, and Galette argues you can't be the state for federal constitutional purposes when your creator says you're not the state under state law.
What about the control issue?
Galette flips the script. They say New Jersey exercises minimal control. No statute gives New Jersey power to affirmatively direct New Jersey Transit to take any particular action.
But the governor appoints board members.
With significant constraints, 10 of 13 board members can only get removed for cause, and this court has said for cause protection eliminates the kind of control that matters.
The veto power?
Galette cites United States versus Arthrex. The power to superintend must imply a right to judge and direct. A veto doesn't give the governor power to direct New Jersey Transit to do anything, just power to stop specific decisions.
And then they make the comparison to municipalities?
Exactly. Lots of state governors have similar appointment and removal powers over municipal officials. Lots of governors exercise veto or approval powers over municipal actions, but municipalities don't get sovereign immunity.
Looking ahead to oral arguments, what should we watch for?
First, expect the justices to hammer on that statutory disclaimer when New Jersey's law explicitly says no debt or liability of the corporation shall constitute a debt of the state. How do you get around that language?
Especially with textualist justices on the bench.
Right. I think the justices will push NJ Transit hard on whether you can claim state immunity when the state itself disclaims your debts. That's the kind of textual contradiction they hate. What about the self-own issue, New Jersey's Tort Claims Act excluding NJ Transit from the definition of the state?
Justice Kagan will definitely raise that. She loves catching parties in contradictions. Your creator says you're not the state under state law, but you want federal courts to say you are the state under federal constitutional law?
That's a tough question to answer.
Watch for Chief Justice Roberts on the competing dignity interests. He cares deeply about federalism balance. When NJ Transit operates in Pennsylvania and New York, those states have dignity interests in protecting their own citizens too.
Which justices might be sympathetic to NJ Transit?
Justice Alito generally defers to state sovereignty claims. He might focus on New Jersey's intent and the governor's control mechanisms, but even he'll struggle with the Treasury factor being so explicit. What about the founding-era corporate separateness argument?
Justice Thomas loves originalist history. Galette has 150 years of consistent precedent saying corporations don't get immunity. That's powerful ammunition. Expect him to ask NJ Transit, can you point to a single founding-era case where a corporation liable for its own judgments received sovereign immunity?
Because they can't.
They can't. And Justice Jackson might raise the Johnson & Johnson hypothetical. If states can extend immunity through legislative labels, what stops abuse? Could New Jersey declare any New Jersey corporation immune?
The practical consequences matter to her.
Absolutely. And watch Justice Kavanaugh on the Treasury factor. He wrote the Port Authority opinion as a circuit judge, emphasizing that at-will removal power allows states to control entities. Here, 10 of 13 board members can only get removed for cause.
So he might see insufficient state control.
Exactly. Plus, that $12.5 million CEO spending authority without board approval, that's massive independence. Justice Kavanaugh might find incompatible with arm of the state status.
Any potential fault lines?
The big split might come on whether founding-era bright line rules still control or whether the modern multi-factor test has replaced them. The conservative justices tend to favor historical practice. The question becomes, do you apply the 150-year corporate immunity rule, or do you balance modern factors?
We'll have full coverage right after oral arguments drop.
This one should produce some fireworks at the lectern. Time for what this actually means. If New Jersey Transit wins and gets sovereign immunity, what happens?
Every state-created transit authority operating across state lines could claim immunity from sister state courts. Metro in D.C. path between New York and New Jersey, BART in California, MARTA in Atlanta. So if a BART train hits someone in California, and BART gets created by a compact between California and other entities, the victim might not be able to sue in California courts.
That seems to conflict with states' ability to protect their own citizens.
That's exactly the competing dignity interest Galette raises. New York has dignity in providing judicial forums for citizens harmed within its borders. Granting New Jersey transit immunity lets it run over a New Yorker outside Port Authority, rear-end a car in Midtown, sideswipe a cyclist near the Lincoln Tunnel, all without answering to New York's courts. But if Galette wins,
the bright line rule from the founding gets reinforced. Corporations liable for their own judgments don't get sovereign immunity. States can create corporations to gain operational flexibility, but they can also claim immunity for those entities while disclaiming their debts. The Treasury factor becomes even more important.
right, if you're going to claim sovereign immunity, the state treasury must actually face exposure. You can't have it both ways, claiming immunity while also claiming the state doesn't pay your bills. And what about state instrumentalities generally?
This could affect how courts analyze lots of state-created entities, universities, hospital authorities, development agencies. Whenever a state creates a corporation with sue and be sued powers and disclaims liability, those entities would face the same analysis. Bottom line time, why does this case matter?
Because it defines the limits of state sovereign immunity in our federal system. Can states extend immunity to corporations they create while disclaiming those corporations' debts? If yes, states gain huge power to shield entities from accountability, and the founding era principles get abandoned.
Right. For 150 years, corporate form meant no immunity. This case asks whether that principle still holds.
But if the court rules for Galette,
It reinforces that sovereign immunity protects state treasuries, not state-created entities that bear their own liabilities. Congress and state legislatures can create independent corporations, but independence comes with accountability.
the Treasury factor matters.
The Treasury factor matters most. When state law explicitly says judgments don't create state debt, claiming those judgments implicate state dignity becomes much harder.
We'll definitely follow this one closely.
That's CSX Galette versus NEWJERSEY Transit Corp. Sovereign immunity meets state-created corporations operating across state lines.
If you made it this far, share this episode with one person who thinks Supreme Court cases don't affect real life. Because anyone who rides public transportation or drives on roads with buses cares about this.
You can find us on Apple Podcasts, Spotify, YouTube. Just search The High Court Report. Questions about this case? Hit us up on LinkedIn at The High Court Report or by email at scotus.cases.pod@gmail.com. Talk to you soon.